Hi there. My name is Baskin Jones. I'm an attorney here in Jackson, and I've got a lot of friends who are therapists and counselors. Usually these friends have questions about the legal process and about how they should respond to requests for records for their clients or subpoenas for records for their clients. I get questions like, can I charge for my time in giving testimony? Can I charge for my time in preparing records? What do I do if I don't keep typed out records? How do I handle that situation? So today I'm creating this video and hoping to provide you some helpful information. I am an attorney that does this sort of work every day. I have clients who have been injured in car wrecks or injured in some other way who come to me and ask me to help them make a claim for damages. Often these folks have post-traumatic stress disorder or some other issue as they recall the trauma of a car wreck or any other type of injury. There's a lot of stress associated with those types of issues. So oftentimes it's my law firm that is sending out a request for medical records as I'm representing that individual against an insurance company and trying to gather all of the records that show how this person has been affected by this wreck. And counselor or therapist notes would be a very useful part of any sort of claim that would be a emotional distress type of a claim. So I'd be interested in being able to hear from a therapist or a counselor. But often there's a lot of hesitation from counselors and therapists about whether or not they want to take part in this sort of claim. Oftentimes I hear from therapists and counselors that they don't even want to treat someone who might have an injury claim associated with their treatment or with their visits with the counselor. They would just turn them away at the door. I wanted to allow some of this information potentially to change your perspective on this topic. I'm always available and open to discuss what it would look like for any of my clients to work with a counselor, what the billing situation would look like, how that would play out. So if you're someone who is looking for additional clients and would be willing to treat someone who has been in this type of an incident, be happy to talk to you about that. Or if you've got a client that has been in a wreck and needs someone to talk to about their injuries, about their insurance claim, I'm an attorney that does that, and I give free consultations. So, to the topic at hand, what is required of you? What is expected of you as a counselor or a therapist when you get a records request? I'm going to pull up a document that is pretty common in my office, and it's a medical record authorization. This is asking nicely. You know, you were ready to get these records. I'm a law firm, so I would send out a request signed by my client for his own personal records. It would have his patient name, his date of birth, social security number. It would have a specific provider that I'm requesting records from here, and it would give a date from the beginning of the time period that I'm looking to get these records from all the way through to usually current date. I'm asking for these records to be sent to my firm, and this is a more general medical type request, but we've checked all of these boxes. And for your purposes, you're going to want to see psychotherapy notes or counseling notes, counseling records, billing reports. Those are the sorts of things that should be coming on a request for you. Here at the bottom, we'll have a signature of the patient, and usually dated within 30 days of the request itself. So what do you do when you get this sort of request? What do you do when you get this request from someone that you have treated? Usually I'm perfectly fine to get an invoice back for these sorts of medical records. It is common practice. You can buy yourself some time as well as you potentially gather these records or any notes that you might have. And in Mississippi, you can charge a rate under the statute, and I can provide you with exactly what the statute says. There's certain fees for the first 20 pages, and then for the next series of pages, and then a rate for every page above that. So you're able to charge by the page. You're able to charge for shipping expenses that could be a percentage of the total amount of the bill. But also, I think there's room here for that counselor, that therapist that has handwritten notes, that if they were going to spend time actually typing their handwritten notes up, for that counselor, that therapist to charge an hourly rate for getting those records back. Again, this is a version of asking nicely, and when you ask nicely, you avoid things like subpoena or subpoena ducis tecum. And subpoena would just be asking you to come and give testimony in a deposition. A subpoena ducis tecum would be a court document that the court, with the judge and the clerk behind an attorney, is saying, we need these records for our processes. And this is what a subpoena tends to look like. There's a legal style at the top of the subpoena. There's a case number, and it's addressed like this, that we're asking the clerk to summon a person, and the clerk will sign and issue this at the bottom, to summon a person to produce to my office at this address or by fax within 10 days the following documents. And here in this general form, any and all records in your possession or control, including but not limited to medical records, case notes, memos, chart entries, and personal notes. And in my mind, that would cover most of the bases of the types of information that you would have. This is bigger than a please would you type request. This, if you do not respond within the 10 days, I've got some options as an attorney to try to force you to provide these records. So at the very least, I would say when you get a subpoena, when you're served with a subpoena, it's usually a process server is going to hand it to you individually, leave it with someone over the age of 16 at your residence, or give it to a receptionist or someone at your place of business. And if that happens, you start running the clock. Keep very clear in mind that you've got this 10 days in which to respond, but I would send very quickly a response to this address or fax number that has been provided and say, we're happy to attempt to get all these records together for you. It looks as if we have this many pages, and it would take this amount of time to produce any of these handwritten notes as a typed up document. If you already have it in typed up form, then you're going to be subject to the same Mississippi statute as far as what you're entitled to be paid for these records. And again, I'll provide you all that information. But sending that early, you've already in some ways said that yes, it's available, but before you get it, you need to pay for these records, and it's perfectly normal to pay. And to do that on the front end. Often also, if you sent your records and sent an invoice with your records within these 10 days, you would be covered from any deadline, as well as it's very likely, in my opinion, that your invoice is actually going to get paid. And with the explanation that these notes were handwritten and they were transcribed, I think that is an okay argument that that time in transcribing those notes should also be paid for. Beyond that, beyond these written documents, when I had that subpoena in my hand, I would go ahead and let your client know that these records have been requested, and it is your plan to comply with the court's subpoena if your client does not let you know in writing that they object to these records being produced within 5 days. And send that to them the best way you know how to get in touch with them, in writing, by email, and to an address. And this allows the court process to work. There's an option for any subpoena that if they ask for way too many records, if they ask for something that is overly broad and unduly burdensome for the person producing the records or for the person whose records they are, that there's an option to file a motion to quash this subpoena, to make this subpoena ineffective, and or ask the court to limit this subpoena in some way. If, for instance, like I have in this subpoena, they ask for records without any sort of time limitation. That could be a lot of records. It could be that they have nothing to do with the claim that is being made in this matter, but I'm asking for those records anyway. That is an argument that could be made by you or by the client. So it's going to take an attorney, and it's going to be a little bit of process for you to make that argument, but certainly you want to let the patient know that they, if they don't want these records being given out, need to act. They need to file the motion or at least tell you that they object, and then it's on them. At least you have asked, and the response you've gotten from your client is, I don't want you to release those, and the other side can take it up with the judge. There's one more element of this beyond this type of subpoena, which is a subpoena requesting records. There are subpoenas for your attendance at a deposition. So instead of saying you have 10 days to give us these documents, it might be that they say, we want to take your deposition in this matter. This, again, is not the nice way to do it. The nice way to do it is to contact you in some way by email or regular mail and to say, we'd like to take your deposition in this case and have you come and sit down with 2 attorneys and a court reporter. You'll be sworn in, and you can tell us about this claim and this particular patient. That's the nice way to do it. The subpoena, you don't have as much choice over when they're telling you to appear or what time. But in a subpoena, they're going to be, at the very, very least, required to pay your mileage from wherever you're residing to the place where the deposition is to be held. And they have to prepay those amounts. It is 100% normal for a provider, a doctor, or an expert witness in these cases to respond that I'm happy to give my deposition the nice way or the subpoena, but here is my hourly rate. Here is the amount of time I anticipate it is going to take me to prepare for this deposition. I'm happy to bring my records, but here are the bills that need to be paid for the expense of these records. And these bills get paid, and they get paid in a prepayment type of arrangement where you are entitled to have a certain amount of preparation at your hourly rate, and then you are entitled to be prepaid in some amount for your deposition before you come and give your deposition. You can have a rate after the first hour that you will be paid additional amounts after the deposition is complete in this amount. And that benefits you in that you're not going to be sitting in a 6-hour deposition if the attorneys can help it. Hopefully, just getting your records would be good enough. Hopefully, you responding to a medical records request or a subpoena would be enough for you not to need to give your deposition. If you do have to give your deposition, I've seen doctors and counselors with hourly rates that it would be $85 to $125 per hour in review, as well as that same type rate, but charged over shorter increments. So let's say every 15 minutes it is, divide that rate by 4, and you would be paid each 15 minutes. They would be ringing up an additional bill. So all of these things are things that might make this process a little more easy to stomach. You should know that from my perspective, keeping my providers happy, keeping the people that are generating these notes about my client and about his trauma that he's experienced, I want everybody to be on the same page. I want it to be clear that the provider can count on me to be reasonable. Some attorneys aren't the same way, but I'm happy to try to continue that level of rapport and to make sure that these providers they don't cringe when they get a request from you to give records or a deposition. I want it to be a process that is easy to work through. I understand some of the uncertainty from your perspective. This is not legal advice on exactly how to handle any of these requests. In a general sense, I would say on your subpoenas, you need to comply. You need to respond, because if you do not respond, there's some pretty steep contempt of court type issues you might run into, where the court will ask you, why didn't you respond to this subpoena, and potentially fine, or there's even the opportunity for incarceration or jail time. So respond, and doing so quickly will make sure that you have time to make sure that your bill is paid before any of these other issues come up. Again, my offices are here in the Jackson area. Again, I am always happy to talk to anyone with an injury claim, with a issue that could involve an insurance company, could involve a car wreck claim, any sort of injury really. If you'd like to get in touch with us here, it is Jones Law Firm. We're here on State Street, just north of Fondren, and the phone number is 601-272-2406. And my email is baskin@outlook.com. But any questions we can answer, again, this is not legal advice. I'm not your attorney, but I'm happy to provide consultations to people to help try to answer questions and make these processes less painful than maybe they currently are. But any other questions you might have, I'm available by email or again by phone. I hope this is helpful.